So the rights and liabilities of auditors, and some of the rights, as you have said, is to access the books, accounts, and the vouchers. So the auditor has all times the right to access and review them, and whether these books are kept at the headquarters or at any other office listed there. The auditor needs to look at the books, then the board of directors will provide the books to them. They have a right to obtain information and explanation as they think necessary for the performance of his duties. And this means if the auditor wants to confirm the bank balance, they may require you to obtain a certificate of balance. This is within their mandate. It's within their duties, and failure to provide that will mean that they will also write that they never had all the information required of them come up with the true and fair view. The auditors have a right to visit branch offices and the right to look at books. And this is where there's more than one office where the auditor deems it necessary to do so. They will ask that they see if your head office is in Nairobi, but you have branches all over. They will seek to see how is the business being done in the other branches. Are they keeping proper books of accounts? So these are their rights. They're entitled to do that so that they're able to come up with a proper view of the books of accounts. The general meetings, and this is also when sending out to the shareholders that we will have a meeting, we will discuss dividends, we will appoint auditors or directors. Auditors must have this communication where the meeting will be held, at what time, and who is expected to attend, and what is the agenda of such a meeting. So they have the right to receive a remuneration for auditing the accounts of the company. For doing that job, they have a right to be paid. And they have a right to make a representation. And this is where we talked about in the AGM, and an auditor has retired, there's a vacancy that has arisen, there is space to be filled. So the auditor, once the board of directors propose to remove this auditor, in that meeting in which the notice will have been sent to both the auditor being removed and to the shareholders, the auditor has a right to make a presentation and demand that this presentation be circulated or to be heard. What we are saying is that he has a right to be heard. Before you remove him, if he feels that this decision is unfair, then he has a right to make his own presentations and say, in as far as this matter is being discussed, I was not liable for these acts laid therein. An auditor also has the right to sue for damages. And this is where his termination is unlawful or unprocedural. So he will sue for damages, and this is what we are saying, action for damages, where a meeting has been called, the auditor has been removed from office. If this auditor feels that this removal was unprocedural, it was unlawful, then the auditor will go again and sue the company to recover any amount lost. We have the liabilities of auditors, and this contractual relationship between the company and the auditor, the auditor owes a basic duty of care to the company. And in so doing, they must disclose any facts which may harm the company. In Hadley, Bryan versus Heller, it's clear that a person may be liable for financial loss resulting from a negligent statement, even if there is no contract between the maker of the statement and the recipient. Although a disclaimer of responsibility will exclude the defendant's liability. So as far as auditors are concerned, recipients of statements are likely to fall into two categories. That is the existing shareholders, who are the members, and the potential shareholders. And this is where we are saying, if a statement is made that results in the existing shareholders selling off their shares and not you being not attractive to new shareholders, this statement that the auditor makes, where it is a misstatement and it results in the loss, then he will be liable to the company. In Caparo Industries versus Dickman, the plaintiff company sued two directors of Fidelity Park Limited Company and the accountant, as well as the auditors. The plaintiff had taken over the auditor and alleged that the profits were much lower than shown in the audited accounts. Therefore, they suffered financial loss. The House of Lords stated that whether a duty of care is owed to a person who relies on accounts to deal with the company or buy its shares, and this is the criteria. One, there's a foreseeability of damage. That in this statement made, do you foresee an example, a situation where the shareholders will sell off all their shares because they do not want to be associated with this company? And this is where we are saying these audited reports that will be presented, they must show a true and fair view. That duty of care you owe, if you break that duty, is it easy to see the extent of your actions, to how far? We also talk about the proximity of the relationship. Who is this that will rely on that relationship? When you give that information to the public, is a person interested in knowing about the books of accounts? Do they have the capacity to contract? And if they don't have the capacity to contract, then no issue, no damage is done. Because whether or not the statement would have been made to be true, this individual would not have made any information or any decision that would have impacted on the company. We talk about the reasonableness or otherwise imposing duty. How have you been able to do this? Have you taken due care, due diligence to ensure that the statements you're making are actually true? And therefore, to establish proximity, these factors need to be present. That the advice was required for a purpose made known to the advice when the advice was given, where the auditor looks at the books of accounts and a shareholder present, since they know them, that they have been appointed in the AGM, approaches the shareholder and asks the shareholder, is there any chance of this company being truthful? If the shareholder answers in the negative, no, there's no chance. You see, the proximity, one, you have asked for advice, and two, you have been given advice. So what have you done with that information? Will it result in a foreseeable loss for the company? Yes, because if I go knowing that these books of accounts have been cooked, then I would not want to transact with this company. In establishing proximity, again, is that the advisor knew his advice would be communicated to the recipient in order that it should be used for this purpose. We go back to that example, is where you know that this information will get to the recipient who had asked for that information. and you know that they will act on that information. And this is where that point will come, that the advice was likely to be acted upon without independent inquiry. A shareholder has identified the auditors for that financial year. The shareholders has approached you and asked you, I want to know, is there any likelihood in 5 years this company will be in existence? You as the auditor go ahead and tell the shareholder, I don't think so, because the directors are not reporting the correct figures. The shareholder will automatically depend on your word. Reason being, you are appointed as an individual, as an independent contractor. You have no reason to lie to the shareholder. And you as the auditor, you know that your opinion is weighty. It's relied upon by not only insiders, but any other user of these accounts and books of accounts. So again, in determining proximity, we ask whether that advice was acted on the recipient's detriment. And when this shareholder comes to you and you tell them you don't foresee the company surviving 5 years, the shareholder sells off his shares. 2 months later, the shares double in price. You see, it's to his detriment. He sold them off at a throwaway price to disassociate himself with the company. Then the company makes a turnaround and makes profit that bring the cost of his shares extremely high. It was at the recipient's detriment that you acted. And in winding up audit, we acknowledge the liability for negligent audit can exist. And these are the factors that will be relied upon. That you as the auditor, having been given access to the books, having been given access to any information, these statements that you make, how do they affect the users of that information? So for auditors, that is where we will stop. Do we have any questions, any clarifications on the same? You can